I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. We find that the majority of problems that come up in equipment leasing happen either at the beginning or at the end of the equipment lease. Those first steps tend to be the ones that trip up a lot of lessors, particularly if they're not sure about what is in their form. Take a good look at your lease form and discuss it with your counsel. Under what circumstances can the lessee return the equipment? Can the lessee simply keep the equipment and inspect it over an unlimited period of time? What happens if there is neither an acceptance nor a rejection at the end of 1 week, a month? Some lease forms provide that if the lessee does not promptly reject the equipment, it is deemed accepted. Now, if you're a vendor captive, that may be a pretty good provision. But if you're a third-party lessor or a funder, that can mean that the money is going out the door for equipment that the lessee doesn't really want, or that your collateral really doesn't have the value you thought it did. We prefer to say that if the equipment is not promptly accepted, the lessor has the opportunity to cancel the financing altogether. That protects both parties. Another thing, recognize that courts have been inconsistent in their treatment of any type of advance acceptance, such as the signing a DNA before the equipment is delivered, or an equipment lease that says the equipment lease begins when the equipment is delivered. The UCC provides a right for the lessee to inspect that equipment. And some judges, the Jazz case out of Hawaii, for example, carefully scrutinize whether the lessee has had the opportunity to make a meaningful acceptance, a meaningful inspection of the equipment. Another thing, it's very common, especially in the small ticket area, to make confirmation phone calls and talk to the lessee after the equipment has been delivered. These are fine, but we had one instance in which one of our clients faced a judge who said that the delivery and acceptance certificate was obviously not intended to be enforceable because the lessor made an acceptance confirming phone call afterwards. If you're going to make confirming phone calls, first, they must always be consistent. If you start making them sometimes and not all the time, it really won't be of any value to you unless somebody can specifically say under oath that he or she remembered that specific lessee accepting the equipment over the telephone. Secondly, don't just rely on it. Again, we never recommend signing a delivery and acceptance certificate before the equipment has actually been delivered and actually been inspected by the lessee. It's just bad business. For more information about this, visit us at www.leaselawyer.com.